We are here for a landlord tenant termination of tenancy hearing. Title of the matter is Riverside Townhouses versus Lateria Walton. Ms. Walton is here, albeit she's about 35 minutes late, but better late than not at all. Attorney Carrie Zenin is here from the Aaron Cox law firm. Lori Cousineau, the manager at that time of Riverside Townhouses, is present. We also had Officer Nathan Hewitt here on overtime in the Zoom connection waiting for the defendant. Also, Attorney Ross Truckee was here, who represents the defendant in some other matters, and I greatly appreciate his sticking around to assist with this matter. Ms. Walton, as you recall, quite some time ago, your apartment complex filed a motion to terminate your tenancy. They wanted you to move. You didn't move, and they filed this action to ask me to terminate your tenancy and take possession of the premises. We were here first on October 23rd, and then we were here again on October 30th. Meg Bauer from Legal Aid was available for consultation at each of those hearings, but did not file an appearance. You had indicated at our last hearing on October 30th that you wish to have a trial on this matter. And so I set up for trial today. So everyone is here live, theoretically, to try this termination of tenancy. I told you on June 23rd and again on June 30th that if you're evicted from Riverside Townhouses, it will most likely make you ineligible to find housing in any other subsidized housing. So there were several efforts that attempted resolving the case with what's called a conditional order of dismissal. Mr. Truckee stuck around today, and it's my understanding he's going to appear for limited purposes in this case only today. Is that correct, Mr. Truckee?
That's correct. I'd appear strictly for the entry of a conditional dismissal agreement on the record today in this matter.
Go ahead and put your name on the record.
It's Attorney Ross L. Truckee for Lateria Walton.
All right, Ms. Walton, did you hear everything I've said so far?
Yes.
Ms. Zanin, are you in agreement with everything I've said so far?
I am, Judge.
All right, so even today, when Ms. Zanin got here, she drove all the way from Warren to be here for this hearing, said we would still do a conditional order of dismissal, so she wouldn't be prohibited from finding other housing. And you guys just met. And I have this proposed consent order for conditional dismissal. And it says rent is zero, court costs are zero, other money is zero because this is a termination. Further conditions, the defendant will vacate and turn in the keys to management by December 15th, 2023, which is 30 days from today. If they had gotten what they asked for today, you would have had 10 days to move out. If there are any new lease violations or police activity, plaintiff can submit affidavit.
Judgment and writ.
Judgment and writ for immediate entry of the court. And if you fail to vacate by December 15th, they can ask for immediate order of eviction. Do you understand?
Yes.
All right, and is that your signature on there?
Yes.
And Mr. Truckee, you discussed this with Ms. Walton as well?
Yes, I did, Your Honor.
And you've signed this document as well?
In the wrong spot, but I signed it.
Well, better there than not at all. And Ms. Zanin, you agree as well?
I do, Judge.
All right, fortunately, we were able to get a relatively quick trial date from October. This is a jury trial day, but because it's opening day of deer season, some people aren't here and no, anyway, we had availability to do it. So, all right, you've got till the 30th or the 15th of December to move. Have you made any effort to find a place to go? All right, now when you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. And so that is a consideration. Now, I told you before that if you did enter into a consent judgment, that the rules were a little bit different. And it probably, I read this to everybody and their eyes just glaze over. Supreme Court says we have to read these instructions to everybody. Now they're even more complicated than they were. But let me repeat what I told you back on October 23rd. If you do reach an agreement and a consent judgment is entered by the court, which you just did, the judgment may not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord tenant hearing, but if the judge did not find in your favor, the original judgment would stand. You understand? All right. Conditional order of dismissal. Entered. Writ date 12/15/23. Now you have a trial set for December 13th on an incident that allegedly occurred last February. And Mr. Truckee is your lawyer in that case. It charges two counts of assault and battery and disturbing the peace. That trial is in front of Judge Pattison. In preparing for this case yesterday, I looked at that case and discovered that the prosecutor has issued a felony warrant for your arrest in file number 232155, which is the incident of July 16th, which is, I think, the same incident that underlies this request. And I don't know why they went from July 16th to November 9th before they filed the complaint. I don't believe it had anything to do with this case. I don't think there was any discussion. I think it had to do with the other case, the one that's set for trial in December. But in that case, it is alleged that on or about July 16th, you did enter a apartment and commit an assault upon Cachet Nichols. They've charged that as home invasion in the 2nd degree. It's punishable by up to 15 years imprisonment and a fine of up to $3,000. Count 2 alleges you made an assault and battery upon Cachet Nichols. They issued that warrant by Assistant Prosecutor Casey Johnson. Officer Hewitt signed it, and the court issued the warrant with no bond. So you're going to go to jail right now, and you're going to get fingerprinted and mugshotted, and I'll see if I can get the magistrate to arraign you before 5 o'clock so they can set a bond. You're not a flight risk. But there'll be some bond conditions. And so you're gonna be taken out to the jail. I'll see if the magistrate can see you within the next hour or so. Are you her ride over here? Have you got her kids? All right, I don't know. You might as well go back to Three Rivers. And this is probably gonna take a while, but it should be accomplished before 5 o'clock. We'll appoint a lawyer for you and set it for further proceedings. Mr. Truckey's already on top of this, and we'll see where it goes. Anyway, you got 30 days to vacate Riverside townhouses that are subject to being evicted. All right, you can take her out to the jail. I'll give this to Luke, see if we can get her arraigned. Ms. Zanin, thank you. Ms.
Thank you,
Cousineau,
Judge.
thank you. I don't see you much anymore, but you got a free trip to Centerville out of this. I guess there's nothing else. But I'm sorry we weren't able to do it sooner than this.
That's okay, Judge. Thank you so much.
Thank you.